we estimate by tens of billions of dollars a year, and most importantly, higher productivity. Today is about freeing Americans from the weight, literally and figuratively, that holds us back. It's about unlocking the potential of every citizen to live fully, to contribute fully, and to find joy in their health. We cannot reach our full potential as a nation if we do not reach our full potential as individuals. And we cannot reach our full potential as individuals if we are not healthy.
All right, people, welcome back to State Line Media. Trump's own handpicked defense witness imploded so completely on the stand, contradicting prior sworn statements, becoming combative and unmanageable, that the judge had to clear the entire courtroom. Legal analysts called it a near-total collapse of Trump's legal position, warning that jurors will hold the spectacle against the defense team for putting such an unreliable witness on the stand in the first place.
Thanks to Nova and Lily for showing up so constructively over the last several months to make this possible. In particular, thanks to you, Mr. President, for again demonstrating that you fight for every American, this time for potential. It's now my sincere pleasure to first introduce Dave Ricks from Lilly and then Mike Dustar from Nova.
Thank you. Great. Thank you, Chris. It's truly an honor to be here today for this historic step forward to expand access to a class of medications that can fundamentally change the arc of chronic disease in our country.
Defense attorneys do not call witnesses without a specific purpose. This witness was carefully selected, prepared, and rehearsed. Whatever he was supposed to accomplish, the calculation that his benefits outweighed his vulnerabilities turned out to be catastrophically wrong. The witness started rushing through answers from the moment he took the stand, a clear warning flag every experienced trial attorney recognizes.
We're hoping, Mr. President, that your friend who has to travel to England to afford these drugs will no longer need to do so and can come and do it in the United States. I'll also just mention that the $149 is $1 less than what you asked us to achieve. Just gonna make sure that's clear. So I want to highlight two other really important points that make me love this deal so very much. First, this isn't about spending more, it's about spending smarter. The savings from the diabetes drug price reductions are being used in a cost-neutral way to fund the new indications for taxpayers. That's amazing, and that happens inside of that same 24-month period. It's cost-neutral. We're spending the money more wisely.
Jurors are not legal experts, but they notice when a witness seems more desperate to escape than to explain. This one was broadcasting discomfort at maximum volume before cross-examination even began. Once cross-examination began, the witness shifted from nervous to combative, arguing with the prosecutor instead of answering, challenging every question, treating the examination as a personal battle.
But second, this isn't just about lower drug prices for Americans, though it does do that, but together with physical activity, with healthy eating and diet, and where appropriate, the use of breakthrough GLP-1s, the real return on investment is healthier Americans, lower chronic disease, lower costs, we estimate by tens of billions of dollars a year, and most importantly, higher productivity. Today is about freeing Americans from the weight, literally and figuratively, that holds us back. It's about unlocking the potential of every citizen to live fully, to contribute fully, and to find joy in their health. We cannot reach our full potential as a nation.
Effective witnesses stay composed and answer directly. This one did the opposite, and in doing so created exactly the impression a defense witness should never create, that he was hiding something. The contradictions with his own prior sworn testimony were the killing blow, not conflicts with other witnesses, but with his own recorded words under oath. Each new inconsistency compounded the last, and by the end, legal observers described his credibility as not merely damaged.
Thanks to Nova and Lily for showing up so constructively over the last several months to make this possible. In particular, thanks to you, Mr. President, for again demonstrating that you fight for every American, this time for potential. It's now my sincere pleasure to first introduce Dave Ricks from Lilly and then Mike Dustar from Nova.
Great. Thank you, Chris. It's truly an honor to be here today for this historic step forward to expand access to a class of medications that can fundamentally change the arc of chronic disease in our country.
But completely nullified. Zero. A defense witness who achieves zero credibility has done worse damage than the prosecution ever could. A judge publicly reprimanding defense attorneys in front of the jury is a departure so significant it communicates everything. The judge had seen enough and was telling the entire courtroom that the defense had crossed a line the court refused to let stand unaddressed.
Of course, these are the incretin or GLP-1 agonists that we've been speaking about. For nearly 150 years, my company, Eli Lilly, has been investing in America. We've been advancing science and creating high-value jobs. But today, are you okay? Gordon, you okay? Yeah.
From a juror's perspective, the sequence is devastating. A nervous and rushed witness, defensive under questioning, contradicting himself repeatedly, the judge reprimanding defense lawyers, and then the entire courtroom cleared. What conclusion could any reasonable juror draw other than that the defense just destroyed its own case? The broader pattern here is essential to understanding why this moment is not an isolated misfortune, but a symptom of something systemic in how Trump-associated legal proceedings unfold. Witnesses connected to Trump operate under pressure unlike anything in ordinary litigation. They understand that Trump himself will comment publicly on their testimony. They understand that his supporters will target them if their words are perceived as disloyal. They understand that their lives and careers and reputations can be damaged based on how Trump characterizes what they say under oath. That environment produces witnesses who cannot think clearly and cannot maintain composure and cannot deliver testimony with the steadiness that effective legal advocacy demands. Some witnesses in Trump-related matters have required medical intervention around their testimony because the stress became physically overwhelming. Some have broken down emotionally on the stand. Some have needed special protective orders and accommodations because of legitimate fears for their safety and stability. Trump has devoted years to cultivating an atmosphere of pressure around anyone who participates in legal proceedings that affect him. He attacks judges and prosecutors and witnesses with equal ferocity. He encourages his political movement to do the same. For a considerable period, this strategy appeared to achieve its objectives. People were afraid to come forward. Potential cooperators hesitated. Witnesses worried about what testifying truthfully would cost them. But intimidation carries an inherent risk that Trump's team appears to have underestimated. Terrified witnesses make terrible witnesses. People who are consumed with fear cannot focus on delivering a coherent and consistent account. People who are simultaneously trying to tell the truth and avoid angering Trump and escape prosecution for perjury and survive public attacks, they crack under the strain. They become evasive and defensive and contradictory. They destroy their own credibility in exactly the manner this witness destroyed his. The intimidation machine Trump constructed to protect himself may have just produced the very outcome it was designed to prevent, the collapse of his own witness in full view of the jury. The implications for the remainder of the trial are profound and will compound as the proceedings continue. Prosecutors observed this entire catastrophe from the government's table, and they barely had to exert themselves. The witness self-destructed largely under the weight of his own inconsistencies and his own inability to maintain composure. That grants the prosecution an immense psychological advantage moving forward. They now know with certainty that the defense has witness reliability problems that are not theoretical but demonstrated. They have seen with their own eyes that pressure can cause Trump's witnesses to disintegrate. They can proceed with greater confidence and greater aggressiveness because a fundamental vulnerability in the opposing case has been exposed, not through speculation, but through live testimony that the jury witnessed directly. The defense team, conversely, has absorbed a blow from which recovery will be extraordinarily difficult. They put a witness on the stand who was supposed to help their client, and that witness instead humiliated them and damaged their case in ways that cannot be undone. Every strategic decision that led to that witness being called will now be second-guessed. Every other witness on their list will be reevaluated through the lens of this catastrophe. The confidence that is essential to effective trial advocacy has been shaken at its foundation. The jury will carry this moment through every remaining day of the trial. Every future defense witness will be viewed through the filter of this collapse. Every defense argument will be shadowed by the question of whether they can be trusted. The credibility of the entire defense operation was compromised the moment that courtroom had to be cleared. The broader message this sends to other witnesses is also significant. People who may be called to testify in this case or in other Trump-related matters observed what occurred. They saw a witness subjected to the pressure of cross-examination, and they watched him disintegrate. Some of those potential future witnesses will now be more reluctant to participate, fearing the same fate. Others may be more inclined toward honesty, recognizing that attempting to maintain an unsustainable narrative under oath leads to exactly the kind of public humiliation this witness endured. The deterrent effect of watching a fellow witness implode on the stand should not be underestimated. Trump has always treated legal proceedings as extensions of his political communication strategy, attacking the process and attacking the participants and claiming victimhood and generating enough noise to obscure the underlying facts. That approach can be effective in the arena of public opinion, or at least in the arena of his supporters' opinion. But a courtroom operates under fundamentally different rules. In a courtroom, assertions must be supported by admissible evidence. Defenses must be constructed from credible testimony. Witnesses must withstand the crucible of cross-examination without contradicting themselves or losing composure or forcing the judge to clear the room. When a star witness collapses in the manner this one collapsed, when the carefully prepared narrative disintegrates under the most basic adversarial testing, all the bluster and all the social media posts and all the rally speeches cannot repair what has been broken. The courtroom is where the story finally meets the truth. And the truth that emerged from this witness's testimony was that the defense cannot be trusted to present reliable evidence to support its claims. The structural damage to Trump's defense position is what ultimately makes this moment so consequential. Defense attorneys do not randomly select witnesses and hope for favorable outcomes. They make calculated, strategic judgments about which individuals can advance which elements of their case theory. The fact that this particular witness was chosen and prepared and presented indicates that the defense viewed his testimony as important to some aspect of their argument. Whatever that aspect was, it is now weaker than before the witness took the stand, not merely unsupported, but affirmatively damaged. The jury heard contradictions. The jury witnessed combative behavior. The jury observed the judge reprimanding the defense and clearing the room. All of that attaches not just to the witness, but to the defense team that chose to call him and to the client on whose behalf he was testifying. Contradicting your own prior sworn statements is the single most efficient method of destroying your credibility as a witness. If you have stated one thing under oath on a previous occasion and you state something different under oath today, at least one of those statements is necessarily false. You may have lied previously or you may be lying now, but you have certainly demonstrated that your word cannot be trusted. Jurors do not require legal training to grasp this logic. It is intuitive and universal. When those contradictions multiply, when a witness cannot maintain a consistent account even within the span of a single examination, there is nothing salvageable remaining. The legal analysts who described the witness as possessing zero credibility were not engaging in rhetorical excess. They were accurately characterizing the legal and practical effect of repeated inconsistent sworn statements on a witness's capacity to persuade. When the neutral arbiter of the proceeding publicly rebukes one side and clears the courtroom, the jury absorbs what that means. The legal system's own embodiment of impartiality has declared the defense's conduct worthy of exceptional measures. That judicial disapproval attaches to Trump himself, and no subsequent legal argument can fully wash it off. The atmosphere of intimidation that Trump has systematically constructed around his legal proceedings has now produced a result directly contrary to his interests. Witnesses who are terrified of being attacked, witnesses who are attempting to satisfy multiple incompatible audiences simultaneously, witnesses who are trying to testify truthfully while also avoiding Trump's anger, while also evading perjury charges, while also surviving the public backlash that follows any testimony Trump dislikes. Those witnesses are psychologically primed for exactly the kind of breakdown this witness experienced. The fear that was supposed to keep people silent and compliant has instead rendered them incapable of delivering effective testimony when called upon to do so. The weapon Trump forged to protect himself has turned back upon him in the most public and damaging possible forum. Prosecutors now possess an advantage that extends beyond the specific facts of this witness's testimony. They have seen the defense's vulnerability exposed in real time before the jury. They can adjust their strategy to exploit that vulnerability with future witnesses. They can approach cross-examinations with heightened confidence because they have witnessed how fragile the defense's evidentiary foundation truly is. The psychological dimension of trial advocacy is frequently underestimated by those who do not practice in courtrooms, but experienced litigators understand that confidence and momentum are real factors that influence how cases unfold. The prosecution just received an enormous infusion of both. The defense just watched both evaporate. The ripple effects will extend to future proceedings as well. This case is not the only legal matter in which Trump has an interest. Other investigations and other potential charges and other proceedings in other jurisdictions will all be affected by what occurred in this courtroom. Witnesses who might be called in those future matters observe this collapse and will factor it into their own calculations about whether to testify and how to conduct themselves if they do. Attorneys representing Trump in other venues will study this catastrophe and attempt to avoid replicating it. But the underlying dynamics, the pressure environment, and the fear and the divided loyalties that cause this witness to implode are not unique to this particular case. They are features of the entire legal landscape surrounding Trump, and they will manifest again. The fundamental lesson of this moment is that courtroom reality eventually catches up with public relations narrative. Trump has spent years constructing a story about his legal troubles, that they are politically motivated persecution, that the evidence is manufactured, and that he will ultimately be vindicated. That story can be sustained indefinitely in the realm of political communication where there are no rules of evidence and no cross-examination and no consequences for inconsistency. But a jury is not an audience of supporters. A judge is not a television host. In a courtroom, the story must be supported by witnesses who can withstand adversarial testing. When those witnesses collapse under the pressure of having to actually prove what they claim, when they contradict themselves and grow hostile and force the judge to clear the room, the narrative that depends on their credibility collapses with them. The bluster cannot save you when the witness you chose to vindicate you destroys your case instead. This is not the conclusion of the story. This is an inflection point. The trial will continue and the defense will attempt to recover and additional witnesses will testify and the jury will ultimately render its verdict. But whatever else occurs from this moment forward, it will occur in the shadow of what the jury has already witnessed. A star defense witness who was supposed to strengthen Trump's position instead detonated it from within. The question now is whether the defense can rebuild from the wreckage or whether this catastrophe marks the beginning of a broader and irreversible collapse. The answer to that question will determine not just the outcome of this case, but the trajectory of every legal proceeding that follows.